Well, for reaction and analysis on today's ruling, I'm joined now by Advocate Michael Osborne, a constitutional law expert from the University of Cape Town. Advocate, thanks a lot for joining us this evening on Newsnight. But this ruling that has been put aside, it says something perhaps really about the state and the credibility in question of our public protector.
Yes, good evening. And I think you're right. It does raise questions as to the competence and the fitness to hold office of the public protector. And what people are going to do is consider today's ruling together with an earlier decision of the same court holding essentially that she had conducted herself inconsistently with her duties when she considered a matter involving the Reserve Bank. There too, the court set aside her decision and held that essentially that she had indicated that she wasn't fit to hold office. Now, in principle, one could anticipate the DA, one of the successful applicants today, taking this back to Parliament and saying that this now constitutes, read together with the earlier decision, this constitutes a firm basis under which Parliament must indeed institute an inquiry into her fitness. And you will recall that back in February of this year, Parliament had refused an equivalent DA request on the grounds that it was premature. The DA now is going to argue that, well, we have yet another decision from a court finding that the public protector has indicated her unfitness. The DA is going to argue, well, now it is time to institute an appropriate inquiry, which may, under the Act, ultimately result in the removal of office of the public protector. It's perhaps premature, though, to speculate upon what Parliament will do in response to this new decision, but certainly it's granted grist to the mill of the DA's request for Parliament to institute an inquiry.
You know, as soon as you say the terms public protector, one notes that the mandate, or one of the mandates of the public protector, is to serve the interests and the protection of the very same public. But it would appear here, I mean, you're speaking about this issue of the Reserve Bank, for example, where the very same North Gauteng High Court actually ruled and said she had no powers for a constitutional amendment to modify the Reserve Bank's mandate. Prior to that, there was that issue with the APSA, where, you know, where she demanded that APSA pay about 1.25 billion rand for Bancorp's apartheid-era loan for the very same Reserve Bank. Now, when we're taking into consideration these kinds of cases that have been leveled and the very same High Court, ruled against her, it says something, though, about maybe playing politics instead of playing for the protection of the people.
Well, yes, just to interject a further note, in the Reserve Bank cases, or one of the Reserve Bank cases, the court ordered, not only set aside the public protector's decision, but ordered that she pay 15% of the Reserve Bank's costs out of her own pocket. Now, that's quite an extraordinary step to take, and it's certainly indicative that in that case, the Reserve Bank case, the court considered her conduct to have been deeply remiss. Now, I'd mention also, with respect to costs, that in today's decision, which concerned not the Reserve Bank, but the Estina dairy farm, Estina in connection with the dairy farm, in that regard, the question of costs has been reserved. Once again, the applicants have sought to compel the public protector to pay costs out of her own pocket. Whether or not this court will make such an order as to cost remains to be seen. But yes, in response to what you said about playing politics, this case does lie at the intersection of politics and law. That's inevitable. And when you have set up in the Act a provision that a particular official will be removed by Parliament, you inevitably creating the situation where political considerations will, of course, come into play when Parliament makes a decision as to whether to set up an inquiry. And it's only to be expected that Parliament, as a political representative body, will not only apply principles of law, but inevitably questions of political party loyalty and affiliation will come into play.
Well, it's certainly a growing case. I mean, we're also going to be hearing from the spokesperson of the Public Protector in terms of exactly where to from here, and is there a decision to appeal or to apply for, direct access to the Constitutional Court. So that conversation will be coming up a little later. But Advocate, thanks a lot for joining us this evening on Newsnight. Just shedding some light as we get responses from that ruling that was set aside by Judge Tolme earlier today, Michael Osborne from the University of Cape Town. As